The DEA should be removed from marijuana rescheduling hearing after illegally conspiring with prohibitionists. A legal filing says, you guys, that's right. A Drug Enforcement Administration, a DEA judge, is being asked to remove the agency from its role in an upcoming hearing on the Biden administration's marijuana rescheduling proposal, with a new legal filing citing allegedly statutory violations that include unlawful communication with a prohibitionist group. I bet you can't guess who that is. When the Department of Justice formally proposed moving cannabis from Schedule 1 to Schedule 3 of the Controlled Substances Act, consistent with a recommendation from the U.S. Department of Health and Human Services. One aspect stood out. The DEA administrator didn't sign the notice of proposed rulemaking, breaking with historical precedent on federal rescheduling proceedings. Instead, it was signed by Attorney General Merrick Garland. That was one of several factors that led to a motion being filed with DEA Administrative Law Judge John Mulrooney on Monday, seeking corrective action. It was submitted on behalf of Hemp for Victory and Village Farms International, which were both invited to participate in the rescheduling hearings that's set to begin next month. A Drug Enforcement Administration judge is being asked to remove the agency from its role in an upcoming hearing on the Biden administration's marijuana rescheduling proposal, with new legal filings citing alleged statutory violations that include unlawful communication with prohibitionist groups, you guys. When Department of Justice... Oh, shit. I'm sorry. Something happened. My bad. The issue isn't just that the DEA Administrator Ann Milgram declined to sign the proposed rule. Throughout the notice, the agency said it needed additional data on a variety of issues, namely cannabis-related health issues and law enforcement concerns, in order to make a complete assessment. The motion argues that the backwards approach to the rulemaking violates federal statute. In a quote, by waiting until the publication of the proposed rule and thus after DOJ initiated proceedings under the CSA, the two flag categories of supposedly necessary data, DEA ensured that HHS would not get to respond to that data in its recommendation and evaluation, the motion says. Even worse, DEA effectively turned the proposal rule into a blueprint for the prohibitionists it apparently was communicating with behind the scenes. Oh, look at that. They were backdooring the information. Another issue that has arisen concerns is DEA's selection of witnesses to participate in the December hearing, which was scheduled following a public comment period that saw tens of thousands of submissions, a majority of which favored rescheduling or otherwise pushed for broader reform, such as removing marijuana from the CSA altogether. Mulrooney, the DEA ALJ appointed to handle the case, recently advised that the agency provided insufficient information about the 25 witnesses who were selected. He ordered the designated participants to fill in the blanks, for example, by making clear where they stand on the question of rescheduling. In doing so, he also pushed back the timeline for the hearing. A preliminary meeting is still set for next month, but it won't be until early 2025, at least until they get to the merits of the case, you guys. And by that time, Matt Gaetz will end up being the Attorney General. And in the new motion filed with Mulrooney's office, attorneys for the petitioners said DEA's lack of transparency in creating the witnesses list is alarming, undemocratic, and betrays notions of good governance. In some cases, seemingly qualified candidates who requested to participate in the hearing did not receive formal denials, and the list submitted to the ALJ didn't itemize the request or provide information about why they were approved or denied. In a quote, you guys, without knowing who the DEA excluded and why, there is no way to assess whether and to what extent the agency's decisions are arbitrary and capricious, the subject of bias or otherwise unlawful, the filing says. In an additional quote, if, for example, DEA included parties with expertise on a particular topic, but only if they opposed the proposed rule, while also excluding parties with even more expertise on that same topic, if they supported the proposed rule, then there would be a powerful case to be made that the agency's decisions were arbitrary and capricious. The filing also argues that by even selecting witnesses in the first place, DEA usurpated the ALJ's role as the presiding officer of the hearing. Among the 25 witnesses that the DEA chose to join the hearing was Smart Approaches to Marijuana, that's right, Project Sam, and the nation's leading prohibitionist group. The filing includes screenshots of social media posts where the group's president, Kevin Sabet, indicated he had private conversations with DEA officials about the rescheduling efforts as Sam rallied opposition to the reform and urged the agency to keep marijuana in Schedule 1. 1 week prior to DOJ's publication of the proposed rule, Sabet posted on X that he could confirm that Milligram wouldn't sign the notice, citing 2 confidential sources inside the DEA and another outside the DEA with intimate knowledge, in quotes. That and other public disclosures added fuel to the latest motion, and in an additional quote, in light of this evidence of improper ex parte communications between DEA and private parties, this tribunal must take all steps necessary to ensure that all such communications are discovered and included in the administrative record, it says. In the relief section of the filing, it also calls on the DEA judge to mandate that records of such communication be preserved. Oh, so they can't just acid wash their hard drives and whatnot. In a quote, unless and until that happens, there will effectively be 2 records of these proceedings, one that is public and incomplete, and another that is secret, complete, and available only to those in the know. Or as Dr. Sabet put it, those with friends in low places, it says. The motion also cites comments given by Sam's executive vice president, Luke Nefardos, who said during a webinar in June that DEA's approach to rescheduling notice offered prohibitionists a roadmap for how to rebut their own proposed rule. Nefardos said in a statement to Marijuana Moment on Tuesday that the filing is wacky and amounts to pure legal theater and no substance. In an additional quote, while it is an entertaining read, we are certain the filing will be rejected, he said. If anything, they have perhaps strengthened the argument for our participation. In any case, the last motion implores the DEA tribunal to, in quotes, use every tool at its disposal to uncover each instance of improper conduct between the DEA and prohibitionists and determine whether those contacts influenced the designated participants list created by the administrator. Requiring disclosure of the ex parte contracts is what the law demands, and because sunlight is the best disinfectant, it will restore confidence in these proceedings, it says. Ultimately, one of the critical requests attorneys for the cannabis companies behind the motion are making is for DEA to lose its status as the proponent of the proposed rule, because the agency allegedly did not follow statutory rules and improperly selected witnesses, including Sam and other anti-drug groups tied to it. DEA is the opponent and cannot bear the burden of proof in these proceedings, they say. It's unclear whether the DEA ALJ Mulrooney has authority to remove the agency itself as the proponent in the hearing, but the motion advises that the judge should instead have DOJ or alternatively Hemp for Victory serve as the proponent. Shane Pennington, a partner at Porter Wright Morris and Arthur LLP, who authored the new brief, said that, in quotes, it is our belief that the DEA cannot lawfully act as the proponent of this proposed rule and that its actions throughout the administrative process demonstrate that it opposes the proposed transfer of marijuana from Schedule 3 and therefore it is compromised. Treating the DEA as the proponent of the proposed rule would violate the Administrative Procedures Act and the DEA regulations and render these proceedings as a sham, he said. Lawyers from the Department of Justice, not the Drug Enforcement Administration, must therefore defend this rule. And meanwhile, a marijuana and psychedelics researcher is asking the DLJ, and that's going to keep on going on and on and on. Man, that's pretty much, there's a lot more to this story, and I'm just going to kind of leave it at that because I think that's really the button up of the story, and I can't wait to hear what you guys have to say about this. I'm glad we got some lawyers on today. Man, oh man, oh man.
Not surprised at all.
Right?
Doesn't surprise me at all.
Go ahead, Dale.
And anybody who's been involved with butting heads of the DEA, and Omar, I want your opinion on this. We can go way back. The DEA are cops. They don't want this to pass, okay? and they have put their thumb on the scale against cannabis from the jump. There have been numerous trials where people have had to jump through multiple hoops, and you finally get in front of a real judge, and the only thing you can talk about is, well, I'm going to order the DEA to take the next step. This is part of the problem we have with the administrative state out there. I've also represented cops before, and I know what they do. They'll tell you they're not doing something, well, behind the scenes, they're doing all kinds of shit. And I believe in turning on the lights and exposing them. I hope they pull their pants down. I have no problem with the DEA contributing and bringing forth factual evidence. But, you know, when you invite the junkyard dog to the table for policy, you're going to get bit. And I hope they pull their pants down and expose them. These son of a bitches have been doing this for decades. They need to stand to the side. I don't support going to Schedule 3. But they're fighting anybody coming forward and proving that there's a current accepted medical use after Sue Sisley proved it. Okay? It's like that should have been the end of it at that point. But they're pissing and moaning about everything here. And, you know, I don't know what's going to happen next. But I want them to be under the spotlight here and explain yourself. Why are you having ex parte communications with this son of a bitch, Sabet? Right. Okay? If you're supposed to be neutral in this, then you're a fact finder. It's like having a judge who's got one of in the pocket of one of the parties. No, it needs to stop.
Right.
Yeah.
No,
ask the Fulton County.
Go ahead.
I was just going to say, ask the Fulton County District Attorney how that worked out, having undisclosed ex parte communications worked out in that young thug trial. It did not work out very well for the prosecution.
No, it did not. That is very, very true.
The young thug.
It shouldn't.
Yeah. What were you going to say, Omar?
Shouldn't work out.
Oh, I think this was a very bold move by Shane Pennington, and congrats to him for doing it. I don't think it's going to succeed ultimately. The DEA is not going to be taken off, but it's really going to make them sweat bullets and have to backpedal and justify themselves. And they will not be allowed to get away with further ex parte communications. And so I'm glad he put him in the hot seat and called them out on it before the hearing itself. We all know that the hearing's going to be a sham, and that there's, you know, really it would result in descheduling, not rescheduling, if they were to take an honest, hard look at the science and be data driven. And so it's all being politically driven. You know, I think the DEA doesn't like anything that takes away from their power. I think there was a famous saying that, you know, it's almost impossible to convince somebody that they're wrong when their job depends on it. And the DEA, even though they're so busy focusing on fentanyl and opioids and have really ignored cannabis crimes, they still don't want that taken away. They still want to maintain their bailiwick and have jurisdiction over cannabis so they can keep ignoring it as long as they feel like it. And it's really created this untenable situation that breeds contempt for the law because people are not following federal cannabis law. And in order to have people not be contemptuous of the law, we gotta have the laws catch up to the people. You know, people don't follow laws. Laws follow people. And our federal cannabis laws need to catch up with the people so that the people will start respecting the law more. I believe in the rule of law, and cannabis prohibition is corrosive to the rule of law. But in the end, I don't think the DEA is going to get kicked off. But my hat off is to Shane Pennington. Good job, bold move. Way to call him out.
Are you guys familiar? Big ups to Hemp for Victory and Village Farms International for taking up this fight for the rest of us. Number one, you guys are. I love the reappropriation of the name Hemp for Victory. You guys familiar with like the propaganda film from back in the day?
World War II.
Absolutely.
Yeah, it's pretty awesome the way they did that. And I thought it was very peculiar that they're headquartered in Texas. Too, of all places.
Well, I mean, hemp is a big thing in Texas. Yeah, hemp's a big thing.
Gotta be the
and
ATX.
TX, not the ATX, the TX. So, I saw what you tried to do there, right there.
I mean, I think hopefully maybe this is a pipe dream, but an unintended consequence of this hopefully is that Sam gets dragged into these court proceedings and maybe they get forced to disclose some of their donors, and we can find out a little bit more about the inner workings of their organization and
how would
where
they
the money
get
comes
forced
from.
to disclose their donors through this proceeding? I don't understand how that would happen.
Because the idea is that we're saying that certain parties have a certain position, right? And finding out what their motive is and where their money is coming from. I don't know. Again, maybe this is a pipe dream, maybe it's a stretch, but
I don't know. That sounds like kind of pipe dreamish to me. What do you guys think, Omar and Adele?
I don't think an ALJ is going to do that. Now, depending on the question, and a real judge, a real federal judge, or a prosecutor going and looking into some stuff, they really have violated the rules. I mean, I'm in favor of disclosure here. We are on a lopsided battle here with the DEA over cannabis. And as Omar said, if we bring the science forward and bring in open-minded scientists, physicians, psychologists, other, scientists that have credibility, and ask them, the question is, why in the hell are you doing this? Why? This is ridiculous. But because it has to go through the power of the DEA and they have a vested administrative and bureaucratic interest to preserve themselves, you get ridiculous positions being taken. And I think that we just need to pull their pants down and make them explain themselves in front of God and everybody. And they don't want to do that because they do nefarious shit.
And to go back to Soham's point, I think you might be able to disclose interested parties that were not disclosed to the court. So if it turns out there's this straw man behind Sam and they're not disclosed in the list of interested parties, and you can show the court that they're not being honest, then the federal judge will open up a can of whoop ass on the party that failed to disclose the interested party. So that's where I think Soham, and I would also feel like there might be a prayer of disclosing who's really behind Sam.
Interesting.
And Soham, it's they're based in Carrollton, so that's outside of Dallas.
okay.
Interesting.
CTX, huh?
Oh God, you guys.
DTX outside of the DTX.
You guys are funny. You guys are so funny. Jenny Beth, you have anything you want to say on this?
There's nothing I can say about Kevin Sabet that I haven't already said, but I hope that this is a very interesting point. I'm glad they're blowing it up. I'm glad somebody's doing something. I saw somebody in the comments making a negative comment about the operator who's doing it. I don't care if you like their weed or not. They're doing something, and they're using whatever money they're making on said weed to try and protect this industry. And until we stand up and throw our dollars behind lobbying for our own best interests, we're going to continue to see more of the same. So shout out to them.
Fair enough.